To actually terminate someone's parental rights, you have this sort of phase one, which is preponderance of the evidence, which is the jurisdiction. Then you have statutory grounds, which is clear and convincing evidence. And then you have best interests, which takes you back to preponderance of the evidence. It's a little more confusing.
So it's not beyond a reasonable doubt.
No, you can lose your kids forever with less evidence than you can lose your liberty.
Wow. Hello, everyone. Welcome back to the Liberty Lawyer Podcast, where we talk about overcoming injustices in the legal system and making sure that you know your constitutional rights. I'm attorney Nick Somberg, your host, and today we have a very special guest, attorney Lisa Kirsch-Satawa. How are you doing today?
Good, thank you. Thank you for having me.
Yeah, thank you for coming on. So why don't you give us first just a little bit of a background about your practice and how long you've been practicing?
I've been practicing for over 29 years. It'll be 30 in May. Primarily criminal defense, but also early career prosecutor in Detroit. I also do education law and really any type of advocacy for people who are falsely accused of crimes.
Now, that's what I want to get into today. You exonerated somebody after being falsely imprisoned for over 15 years.
Yes. We had an opportunity, we being the Innocence Project at the University of Michigan, myself and several other trial lawyers in Michigan, to help not only get someone exonerated, but the litigation that goes on to get to that point. He served 16 years in prison. He was 19 when he was originally arrested. He was a man of a lower IQ, had some mental disabilities that were exploited upon his arrest, and that he gave a confession to the rape and murder of a woman in her 80s. This was in a small town in northern Michigan, and really the whole town knew him, the whole town knew her. It turned this location upside down.
So how long ago, what year was he convicted?
I believe it was 1998.
And what were his actual charges?
There were multiple counts. It was felony murder, and the underlying felony was the criminal sexual conduct or rape, that he had broken into her house and somehow overcome her and committed these offenses and then killed her.
How did you come to get this case? How did you become the attorney over the exoneration?
So what happens is the initial stages, when a case comes to the attention of an Innocence Project or a conviction integrity unit, it goes through a process to see if in the DNA cases is the easiest one to explain, and that is if the DNA technology didn't exist when the initial case was investigated, and it exists now, can we test it? Can we make sure that it's the right person? In my case that I worked on, the science didn't exist at the time of his conviction to test the DNA sample because of its size. It was too small. So what the process that happens is once it comes to the attention of one of those groups, then there's attorneys who try to get the prosecutor of the county where the conviction was to stipulate to test the DNA again. And in this particular case, the first prosecutor said no. Again, this was a very, very small town, and so the town was very divided, and it was just like you see on TV.
So you're saying that a prosecutor has to agree to reopen a case and to
test the DNA.
test DNA. And the first prosecutor didn't want to do this.
Right. So we were stuck.
Why, with the advent of this newer technology, where you could prove somebody innocent or not guilty, I mean, why would anybody who takes an oath to follow the Constitution, to ensure justice, to act fairly, why would anybody say no to something like that?
If there was justice in that case initially, we wouldn't be talking about it. It's a scary thing when you have very highly emotional, a lot of media, a lot of community involvement, a lot of loved people who have been victimized, killed, injured, whatever it is. Our society doesn't look at people and say, oh, I wonder what they're innocent of. We see someone pulled over on the side of the street and we're like, oh, I wonder what he did.
What did they do?
And so so you have prosecutors sometimes,
yes,
who, the defense bar calls them true believers, who there's just no way they could ever get it wrong. And for whatever reason, it was politically charged, so you can look at it from that standpoint. That prosecutor wouldn't agree. That the victim's family, had their closure, they had their guy, he's in prison, we're not going back there.
How many trials have you had in your career? Have you kept track?
I know that it's well over 200, but I don't know.
Congratulations.
How many.
I just had my 35th
Yay.
last week. Now, one thing that you brought up, I find it really hard to overcome people's general bias. Like you said, when someone's pulled over on the side of the road, and you're like, what did they do? To really explain to somebody the presumption of innocence and how strong that is. Have you, in your experience, how do you, when you're selecting a jury, educate them on presumption of innocence? And do you have any advice for any lawyers out there?
I think that, that really explaining that it's counterintuitive thinking, and I'm giving them that example of either what you saw on the front page of the paper, what you heard on the news, and the example, you have to know your jurisdiction and everything, but, when we hear about a school shooting, we immediately, what was wrong with that kid?
Right.
We have a lot of rush to judgment, just as a society, and so you have to educate them about why it's important to have the presumption of innocence. How you can't prove that you didn't do something.
Yes.
And usually, talking to them, give personal stories, with their own kids, and how do you decide who did it?
And this is all done. This is all done during jury selection.
Yes.
Okay.
Yes. If there's any, I say they're like my big three that you must educate your jurors on. It's always the burden of proof, the presumption of innocence, and the client not testifying or the defense not having to do anything.
So something I do in every trial for presumption of innocence, I think I get a lot of light bulbs when I do this, but I go, ladies and gentlemen of the jury, think of the last person in your life who would commit an assault and battery. And I want you to visualize that person in your head. Maybe it's your mother, maybe it's your pastor, your brother, your sister, and think about that person. And I might go, juror number 2, who's that person for you? I go, oh, well, it's my wife. I go, and what if I went up to you and said, your wife assaulted me? Would you believe me? I say, well, no. I said, now, what if 2 people said, we saw your wife assault somebody? Would you believe them? And they still say no. And I explain to them, I'd say, I go through a couple of people, give the example, your grandma, your pastor, or whatever. And I say, now, if you knew my client, you couldn't be on this jury. And that's what we're asked in the beginning. But that feeling and belief that you have for your mother, for your pastor, for your wife, that feeling that you have for that person, that's the presumption of innocence. And that's what you need to project onto my client throughout this entire trial. And I kind of go through and we have people
Yep.
like, oh. So how did you get assigned this case in the first place? How did you become the lawyer to exonerate this person?
Well, after the first prosecutor was not reelected and we had a new prosecutor, that prosecutor agreed to have the DNA retested. And it did exonerate our client, but the prosecutor's theory was that he must have been wearing a condom.
So when he was convicted, they had DNA evidence saying it was him?
No, they couldn't test it.
It was too small of a sample to even test.
Correct.
Now, modern day, they can test extremely small samples. Now we have very precise instruments.
Yes, and they can also multiply the sample to keep its integrity and create more, so you can test and test and test.
So he was in jail from, 1998?
8.
For 16 years. So he's in there pre-9/11 to 2014 or so.
Yes.
Modern times. Have you seen him since he got out?
I have.
And how's he doing? What does he think?
Well, I have not seen him in quite some time now. He did successfully sue the state of Michigan and had a large financial recovery.
Great, good for him. But you can't take those years back.
He was 19 and he got out and he was in his mid-30s and he missed the internet. He didn't know what email was. He didn't know what cell phones were.
Right.
His first meal out of prison was at IHOP. He ordered everything that had strawberry on it on the menu because when he was in prison, he would see the commercials for IHOP, and he just wanted what he saw on the commercials because that didn't exist before he was in prison.
Congratulations on that case. That's huge. You're doing God's work, getting innocent people out of jail, and it is scary. Our system, I think, has room for improvement. It's probably one of the best, if not the best in the world. But still, the fact that innocent people go to prison in modern times just blows my mind. And people who get selected for a jury, some people don't want to ever be on a jury. Now, you or I, we're going to get kicked off quick as soon as we say what.
I have been kicked off.
Well, as soon as we say what we do for a living, you're off the jury. But people who want to make a difference, like, they don't realize that you have more power than the judge. You're the most powerful person in that courtroom.
For sure. And
you can say not guilty, and there's not much that, if anything, can be done to override you.
One thing that I just had a 7-week jury trial, and I cannot even believe how long my jurors sat there and then deliberated for days. And afterward, they were so mentally drained. It was so interesting to talk to them, and I think it happens in every trial, but this one was just so much because it was so long, where it's a very hard decision. And I think for the most part, jurors, like I said, jurors try to do the right thing that comports with the evidence. But I've had, juries where someone didn't disclose that they knew all about the case and had read all about it in the newspaper, and they already knew this, and this that wasn't admissible. And, that jury at the end was, thankfully, they didn't come to a verdict. They hung because this one person would not move off of what they read in the paper and wouldn't follow the instructions and only make their verdict or decide their, the case based on the evidence in the courtroom. But if you don't ask the right questions when you're picking the jury,
right,
things like that can slip through. And so it's really important. Here's the lawyer tip. It's really, really important to ask every juror if there's any important question that you should have asked them that you didn't ask.
During jury selection.
Mm-hmm.
I want to ask you now, you deal a lot with parental rights.
Yes.
And you have fought for parents that have had their children taken away by the state.
Yes.
What sort of rights does somebody have as a parent?
Well, basically, there's a United States Supreme Court case that gives parents a fundamental right to raise their children. So that gives a parent the choice for how they are going to care for their child and how they are going to provide that child's basic needs. It also, gives parents the freedoms guaranteed by the Constitution, the freedom of religion. You have a freedom of where you want to live. You have a freedom of what schools they're going to go to. Whatever nutritional choices you make and provide for your child. If you believe in medical care or not, vaccines or not. And so inherently, as a parent, you have the right to make those choices for your child.
So I have the right to raise my children how I see fit. Now, it's been a lot in the news lately. Is it your fundamental right to as a parent to tell your child that they can pick if they're a boy or a girl? And do you think that can be confusing to a young person?
Yeah, I have to answer that question from two different perspectives. Legally, I don't think the law is there yet and has spoken to the propriety of that conversation or not. I would assume that it is absolutely your right as a parent to talk to your children about whatever you want in whatever fashion you want to. From a psychological perspective, though, it really strikes me that that's no different than the parents who are constantly interviewing their children if anybody hurt them, if anybody was mean to them, and kind of suggesting that something must have happened. So if you have the younger the child, the less of their frontal lobe of their brain is developed, and they can't really distinguish, the younger they are, between something that really happened to them and something that someone told them happened to them. So if parents are constantly having a conversation and the child just wants the conversation to stop or the questions to stop, then they're going to just agree with the parent, the teacher, the adult, because kids believe that the only reason that questions are asked multiple times is if the answer was wrong the first time.
So the younger a child is, the more suggestible they are.
Yes,
right?
But all people are suggestible.
Sure. And if I were to tell a biological boy at 4 years old, you sure you're not a girl? You sure you're not a girl? You sure you're not a girl?
It may cause them to question themselves and not develop, and not have that personal development of someone who is strong and confident and smart and secure and safe. I mean, if you're constantly asking a child to question who they are, how do they ever get comfortable that who they are is right?
Or children need that foundation, that security. It's fundamental for their growth.
Absolutely. And I mean, there's some great books out there. One of my favorite ones is How to Raise an Adult. And, there's a lot of books about raising kids, but and it's all about parenting for who they will be.
I think people would like to know how does a parent lose their parental rights and how do they get them back?
Well, once you lose them, it's very, very, very hard to get them back. Basically, in Michigan, we have mandatory termination if a child is severely physically or psychologically injured, or if they have been sexually assaulted, or there's some presumptions if a sibling has been seriously physically injured or killed that the parental rights should be terminated. And the statute is written that is the mandatory relief that the state must seek in those circumstances. There are other less severe forms of abuse or neglect where the state will come in and sort of suspend parental rights to rectify the situation so that the kids can be returned.
What's their standard of proof? I mean, when you charge someone with a crime, they have to have probable cause, and a judge signs off on a warrant. But to take take your children from you, how much proof or evidence do they actually need to have to make that decision?
Initially, for kids to be taken, it's probable cause. It's not a legal determination. It's basically a social worker, protective services worker, or a police officer, files the appropriate paperwork. The prosecutor petitions the court. The children can be removed. The process goes on, like I spoke about earlier, kind of the parental rights being suspended. That is called temporary custody, or the court taking jurisdiction, attempting to rectify whatever situation caused the children to be removed in the first place. And that in that scenario, if that's a preponderance of the evidence, so that's 51% that these kids are in a situation that needs to be rectified.
And where do these kids go when they're taken from the parents? Do they first try to place them with like a close family member, or is it just to the state? There's
always a preference that placement be with a relative. After the relative, it's what they call kinship care, which could be, a close family friend who they call aunt, or, someone like that. And then the third option is foster care. But going back to what you were asking about the burden of proof, to actually terminate someone's parental rights, you have this sort of phase one, which is preponderance of the evidence, which is the jurisdiction. Then you have statutory grounds, which is clear and convincing evidence. And then you have best interest, which takes you back to preponderance of the evidence. It's a little more confusing.
So it's not beyond a reasonable doubt.
No, you can lose your kids forever with less evidence than you can lose your liberty.
Wow. So, Lisa, there's a lot of parents out there. What should a parent know in order to protect themselves so something like this never happens?
Unfortunately, you can't prevent it from never happening, because we have mandatory reporters, and they can be charged with a crime if they don't report, and that's based on just suspicion of abuse or neglect, that a child may be in danger. It's suspicion. It may happen, even if you're a great parent. So the most important things are basically what you say in front of your kids, because, if you're walking down the street and you say, like, oh my goodness, that guy is such a creeper, your child could then go to school and say they met a creeper with their mom. Well, now you've created an unsafe environment for them, according to that teacher. Wow. Like, it can happen like that innocently. Parents take their kids to the emergency room every day, and they don't have an explanation for the injury. If you don't have an explanation for the injury, or they don't believe you, or they don't think it's consistent with the injury, they're going to call protective services, and they're going to call the police, and you're in the middle of this, so fast. So what to do? Document, document, document. Write down every person you talk to, every person, when it comes to your kids. You go to the pediatrician for a well visit, write down anything that you talked about, anything that the doctor checked out, every time you call the pediatrician to ask questions. If you Google something, I had a case recently where the child it was a baby who had a broken femur, and it happened because the parents were doing a bicycle motion that they learned on YouTube to relieve the baby of gas. That can cause a fracture if you do it like with the right amount of twist or torque. And people are accused of that being an abusive injury all the time. And if you don't, have that video or that printout or whatever, you're not going to think about it, that could have caused it when they ask you if you have an explanation.
Are most reporting done by teachers and government people? I mean, you say it's mandatory reporting, but is it like other family members?
No, the only people who have an obligation as a mandatory reporter are basically people who, like law enforcement, doctors, nurses, child care providers, teachers. Lay people don't have an obligation unless they're also one of those categories.
Okay. Now, as you know, I'm running for Congress, and we got to write the laws. In your experience, is there any way we can improve the law to better protect kids and parents?
Well, nationwide, the child welfare system is very, very broken. I can't tell you one state that is doing it right. There are some states that do it better. Michigan is doing it better than they were in 1992 when I started working in this child abuse world. I was a student then, but there's no consistency. If you are an inner city kid, there's a lot more that will be overlooked than if you're a suburban kid before it's reported. And I had a friend who was a teacher in Detroit. She used to say to me, how many cigarette burns does this child have to come to school with before anyone will do something?
Well, it's just people they have lower expectations, or
there are some cultural explanations, and they're tolerated in some communities, like being whipped with a switch, for example, or a telephone cord. They loop the cord, or a belt.
There's no standardization. You said there's inconsistencies depending on where you live.
You would have your rights terminated in northern Michigan, for example, if someone had multiple cigarette burns. You would lose custody of your child in many counties of the state if you neglected to send them to school. In the city, they get like opportunity after opportunity after opportunity, which they should. But at the end of the day, if the parent can't get up to get their child to school and they're not around to help them do their homework and succeed, even though children have a right to have their parents raise them, just like parents have a right to raise their children. But you have to really evaluate it for, if we want to break, the pipeline to prison, we have to, these kids might need intervention. That might be the right thing. But do their parents' rights need to be terminated? I don't think so. They need, that's where you really need to educate and intervene and provide services. But some people just won't take them, and nothing will change, and it can't be safe. And that's when the state does have to take pretty extreme action.
Well, Lisa, there are so many more things I'd like to ask you about.
I'd love to come back. This was really nice.
But this is very, very interesting, and thank you for your perspective, because I know a lot of parents don't know about this stuff. Right. And people don't know that, hey, they could be very innocent, and they could be even asking for help. And in asking for help, say, hey, we watched this YouTube video, I was bicycle kicking my kid, and he fractured his foot, and now you lost your kids. So thank you so much for coming on the show, and I really appreciate it.
Thank you so much, Nick.
Thank you.
Good luck to you.
Thank you. Thank you for watching the Liberty Lawyer podcast. If you enjoyed this content, please subscribe, follow. You can follow us on all social media platforms to have more content like this.